Now we'll begin the last session of the conference. Session 5 will be conducted under the topic of settlement of disputes under UNCLOS. Without further hesitation, it is time to welcome our panelists for Session 5. This session will be moderated by Dr. Hwang Jun-sik, Director General at the International Legal Affairs Bureau of the Ministry of Foreign Affairs of the Republic of Korea. Director General, we invite you to begin.
Good afternoon. Welcome to the final session of the conference. My name is Hwang Jun-sik. I'm Director General for International Legal Affairs for the Ministry of Foreign Affairs of the Republic of Korea. First, I'd like to thank all the great panelists for their excellent presentation and interventions. And also, I'd like to especially thank all the members of the audience, especially young students, for packing this room with interest and passion. I'm so pleased to moderate this session with distinguished speakers and discussants. Well, up to session 4, we have discussed some of the most important substantive issues of UNCLOS, and it was really inspiring and insightful discussion and full of interesting arguments and counter-arguments. And in this final session, things get more exciting, And our speakers will address dispute settlement, a fitting conclusion to the two-day conference on the past, present, and future of UNCLOS, because the dispute settlement mechanism introduced by UNCLOS kind of encapsulates why this convention has been such a remarkable success. An assessment of the 3 decades of UNCLOS would be incomplete without examining how it fared in the discussion settlement area. And I know that this is a room full of the world-leading experts on international law and the law of the sea, but there are some students and the members of the audience who are not familiar with the actual mechanism and the provisions of UNCLOS. So if you bear with me, let me give you a 1-minute summary of the dispute settlement system. It is a very comprehensive and complicated system, but it starts with the simple obligation to settle disputes by peaceful means. And you are totally allowed to resort to non-judicial and other mechanisms outside UNCLOS in the initial stage. But if you fail to reach any settlement by these means or mechanisms, then you may be subject to compulsory procedures involving binding decisions. Still, you have a choice of forum, ICJ or ICLS or arbitrary tribunal, and some special arbitrary tribunal. And even with those compulsory procedures, you're allowed to invoke certain limitations and exceptions in accordance with the relevant articles. Okay, it's done and very rough, but it took less than a minute. Now, let me introduce our panelists. You may refer to the program book for more detailed professional experiences and achievements of each panelist. Our first speaker is Professor Mathias FORTEAU. Professor FORTEAU teaches at the University of Paris Nanterre and is a member of the UN International Law Commission. Professor FORTEAU will give an insightful assessment of the UNCLOS dispute settlement system with focus on the interplay of the choices of means of dispute settlement with a potential forum shopping strategy of states parties. So for the efficient use of our time, each of our speakers will present for about 20 to 25 minutes. And following that, the discussants will talk about 10 to 15 minutes to share their comments and pose questions. And I'd like to open the floor to the audience for a few questions depending on the time. And we'll ask the speakers to respond to those questions and comments. Now I'll ask our first speaker, Professor FORTEAU, to take the floor.
Mr. Chair, Excellencies, ladies and gentlemen, I would like first to extend my sincere thanks to the organizers of this new editions of the International Conference on the Law of the Sea for their invitation. It's a great privilege and a great pleasure to be here today and to have the opportunity to participate in this panel and in this wonderful conference and event. What I propose to do today is to address the choices of means of dispute settlement under the UNCLOS and more specifically the issue of forum shopping under the UNCLOS. As we all know, Part 15 of the UNCLOS, which is dedicated to the settlement of disputes, constitutes probably the most important development in the settlement of international disputes since the adoption of the UN Charter. It was in 1982 without precedent in the history of international adjudication, and since then, there has been no real comparable achievement in terms of dispute settlement in a multilateral treaty of that ambition. One crucial aspect of Part 15 is the choice of forum. Under what has been called the Montreux formula, the parties have been offered a choice between different dispute settlement means. In and of itself, such a choice opens the door for forum shopping. Since dispute settlement practice significantly developed over the last decades, it appeared to me that it was necessary to reassess 30 years after the entry into force of the Convention, the forum shopping dynamic of the regime established in Part 15. On that basis, I tried to explore the situation existing today in terms of forum shopping under the UNCLOS, and that led me to two main conclusions that I will present today in a synthetic way. The results of my research are developed in a much more detailed way in the written version of the paper I prepared and submitted for the purpose of this conference. These two conclusions are to some extent in opposition to each other. My first conclusion is that there exist today, at least to some extent, more choices in terms of dispute settlement under the UNCLOS than what was initially envisaged in 1982. My second conclusion, on the other hand, is that forum shopping between UNCLOS court and tribunals reduced over time due to the increasing convergence between them in terms of decisions on the substance and also in terms of applicable procedures. In a nutshell, there are at the same time more choices and less choices as compared to the situation that existed 30 years ago. I will address in turn these 2 points, and I will start with the first point, the fact that there are today more choices open to the parties to settle their dispute under the UNCLOS. In the last 30 years, the focus has been mainly put on Article 287 of the Convention regarding the possible choice between the ICLS, the ICJ, Annex 7 arbitration, or Annex 8 arbitration. To focus only on the contentious proceedings before these courts and tribunals is, however, too reductionist. Part 15, indeed, established a much more sophisticated system which offers multi-level choices for the settlement of disputes. And these choices evolved over time in 3 regards in particular. First, Part 15 of the UNCLOS is not limited to the choice between different courts and tribunals. It also contemplates recourse to diplomatic or political means of dispute settlement. The possibility to have recourse to non-adjudicatory means of settlement of dispute is quite important and too often underestimated. International courts and tribunals are, of course, important, but they are only the very tip of the iceberg. The overwhelming majority of disputes or problems arising in the course of the application of the UNCLOS are settled amicably or in a very pragmatic operational mode. It is important to recall it and to stress it, in particular in light of the increasing importance of the obligation of cooperation, which was in particular stressed in the advisory opinion of the ICLS last May on climate change. The necessity not to forget the important role played by non-adjudicatory means of dispute settlement is confirmed by the evolution reflected in the BBNJ agreement adopted in 2023. Before this agreement, multilateral conventions used to follow 2 main patterns. Some contain robust dispute settlement provisions, but no monitoring or compliance mechanisms, while others contain such compliance mechanisms, but no strong dispute settlement regime, as it is the case for a number of multilateral environmental agreements. By contrast, the BBNJ agreement contains both. Article 60 refers to Part 15 of the UNCLOS, and in addition, Part 8 of the agreement is devoted to implementation and compliance, in particular through the establishment of the Implementation and Compliance Committee, which, I quote Article 55 of the agreement, shall be facilitative in nature and function in a manner that is transparent, non-adversarial, and non-punitive. That is a significant evolution. In light of this evolution, one may ask whether the interpretation of Articles 283 and 286 of the UNCLOS should not evolve. These two provisions provide that recourse to a court or tribunal under Section 2 of Part 15 is possible only, I quote, if no settlement has been reached by recourse to Section 1, that is to say, by any other dispute settlement means. Articles 283 and 286 operate as a gateway between non-adjudicatory means and adjudicatory means. International court and tribunals have so far interpreted these two provisions very flexibly as referring only to a mere procedural condition that can be easily satisfied, to a point that these two provisions have become, in fact, empty shells. It may be that the interpretation of these two provisions could or even should, in the future, evolve to pay a better tribute to the practical importance of non-adjudicatory means of dispute settlement and the multiplication of compliance mechanisms in the law of the sea and the law of environment. Second, advisory proceedings became, over time, a new competitor in forum shopping. Here again, the situation evolved since the entry into force of the Convention. As it is well known, the ICLOS incorporated into its rules of procedure a specific provision that allows the tribunal to give advisory opinions, even though that was not contemplated explicitly in the statutes. The insertion of this provision was challenged by a number of states when it was for the first time resorted to in 2015. Interestingly, when a second request for advisory opinion was submitted to the tribunal on climate change in December 2022, state parties this time refrained from challenging this provision except for very few states. And many states participated in these advisory proceedings. In addition, the BBNG agreement also confirmed the possibility to ask advisory opinions to the ICLOS. The result is that today, advisory proceedings before the ICLOS, and in fact also before the ICJ, have to be added to the panoply of available dispute settlement means in the law of the sea and to be integrated into any forum shopping strategy, something which was not certainly anticipated when the UNCLOS was adopted in 1982. Third, the parties can have recourse to dispute settlement means outside the UNCLOS by virtue of Article 281 and 282. It's not the proper place here to discuss here in detail these two provisions and how they have been interpreted in case law since 1994. What matters is to stress that these two provisions exacerbate one step further forum shopping strategies. The picture became even more complex following the judgment of the ICJ on preliminary objections in the delimitation dispute maritime delimitation dispute between Somalia and Kenya in 2017. Because in this case, the court adopted a very broad meaning of the term agreement in Article 282, and then a broad interpretation of the possibility to have recourse to other means of dispute settlement outside the UNCLOS. In addition, it became clear over time that the law of the sea disputes can also trigger dispute settlement regimes under other rules of international law. A dispute on the UNCLOS can be framed as a dispute on the interpretation or application of other rules of international law, such as, depending on the circumstances, the use of force, human rights, the law on immunities, or investment law. When selecting the most relevant forum in relation to a dispute with law of the sea aspects, the parties can contemplate other treaties than the UNCLOS. And that adds another layer of complexity in law of the sea forum shopping, which materialized, for instance, recently before an ICSID arbitral tribunal. In the case Peteritz-Pildegovic versus Norway, which was settled last year, an investment arbitral tribunal had to address the restriction of the fishing of snow crab in maritime zones under the jurisdiction of Norway, and it had to do it under a bilateral investment treaty which overlapped with the law of the sea. The recourse to means of dispute settlement outside the UNCLOS can result in the superposition of multiple claims before different courts and tribunals on the basis of different rules in relation to, in fact, the very same issue, as exemplified recently by Mauritius' litigation strategy regarding the Chagos, or by the successive requests for advisory opinions on climate change before the ICLOS, the Inter-American Court of Human Rights, and the ICJ. And what should not forget too, the important role played by domestic courts in law of the sea disputes. To conclude on the first point, the choice of dispute settlement means open to the parties in relation to the UNCLOS has not only revealed its full potential, it seems that it has also expanded, at least in some respect, since the entry into force of the Convention. And by the same token, possibilities of forum shopping have multiplied. Insofar as forum shopping between UNCLOS court and tribunals is concerned, there are, however, today, limits to such forum shopping. Since 1994, indeed, the case law and procedural rules are more and more convergent, meaning that there is eventually less room for having competition between UNCLOS court and tribunals. This is my second conclusion, to which I turn now. Obviously, there remain today differences between the ICJ, the ICLOS, and arbitration under Annex 7 or 8, but over the last 30 years, the trend has been towards reducing such differences, which in turn necessarily reduced the possibilities to develop forum shopping strategy. And I will make 3 observations in that regard. First, on the substance, the risk of fragmentation of the law of the sea did not materialize since the entry into force of the Convention. Quite to the contrary, we assisted over the last decades to a great convergence between the ICJ, ICLOS, and arbitral tribunals in the identification of applicable rules and the solutions arrived at in specific disputes. And this is particularly true in the field of maritime delimitation, at least for most of the points that have been addressed in the last year, a possible exception being maybe the way gray areas beyond 200 nautical miles have been addressed. We had a very interesting discussions yesterday on this issue. Second, over time, Annex 7 arbitration become less and less ad hoc in nature, and as a result, the differences between arbitration and recourse to permanent courts and tribunals are less and less obvious. Why? To start with, because Annex 7 arbitration is not of a purely ad hoc nature, since the main arbitral procedural rules that are in Annex 7, or 8 if applicable, are common to all arbitral tribunals under UNCLOS. In addition, the rules of procedures that each Annex 7 arbitral tribunal has adopted over the last 30 years have largely been similar, bearing in mind that, save on one occasion, all Annex 7 arbitrations were administered under the auspices of the Permanent Court of Arbitration. There have been, of course, evolutions over time, the first rules of procedure being less sophisticated than the most recent ones. In the first Annex 7 arbitration, the bluefin tuna case, no formal rules of procedures were adopted. In the second case, the MOX case, they consisted of 18 articles and were 7 pages long. The most recent arbitration is Rules of Procedure is a 12-page document with 28 articles. And what is remarkable when a detailed comparative analysis of the rules of procedure adopted by Annex 7 arbitral tribunal is made is that the procedural regime often developed by successive addition, a new procedural rule being in general incorporated in subsequent rules of procedure in other cases. That was, for instance, the case for the now common standard section on transparency. A specific section on transparency appeared for the first time in the rules of procedure in the Enrica Lexi incident in 2016, and since this case, the rules of arbitration in other cases incorporate a detailed section on transparency. More generally, what a detailed comparative analysis of the rules of procedure adopted by Annex 7 arbitral tribunals show is that Annex 7 arbitration has been largely driven in the last decades by a process of standardization which results in a form of institutionalization of arbitration. The fact that Annex 7 arbitration is less and less an ad hoc means of dispute settlement in the full hands of the parties to the dispute is reinforced by the significant evolution that took place with the Chagos arbitration. Before that arbitration, the rules of arbitration used to indicate that they were adopted by the parties themselves. For instance, in Bay of Bengal, the rules indicated, I quote, that the parties have agreed on the following rules of procedures. In Chagos, the tribunal decided to disconnect the rules of procedure from the will of the parties by using the following sentence, I quote, the arbitral tribunal, in consultation with the parties, has adopted the following rules of procedure for the arbitration. And the very same approach was followed in all subsequent cases. It means that the tribunals now make clear that they are the ones adopting the rules of procedure. Annex 7 arbitration is thus less different than the ICLS or the ICJ than before, and in a way less attractive for the state parties as it used to be, because states are not any longer in a position to fully control the arbitral procedure. Third, the procedural differences that remain between unclosed court and tribunal should not be overestimated. To begin with, the unclosed contains in Part 15 important rules that are applicable to all courts and tribunals covered by the choice of procedure under Article 287. In particular, Article 288 on jurisdiction ratione materiale, Article 291 on access to unclosed courts and tribunals, Article 293, which is very important, on applicable law, Article 294 on preliminary proceedings in case of abuse of legal process, Article 295 on exhaustion of local remedies, or Article 296 on the final and binding force of decisions. In addition, even though there are procedural differences between the ICLS and the ICJ statutes and rules of procedure were still the main source of inspiration for the ICLS, and in many respects, the two are functioning in a similar fashion. The same can be said, to some extent, for Annex 7 arbitration. A number of examples actually show that since 1994, similarities largely prevail over differences. For instance, the ICLS decided in its first advisory opinion to follow the ICJ jurisprudence with regard to the assessment of jurisdiction and admissibility, with some of the judges making dissent opinion in this case. Similarly, the arbitral tribunal in Chagos decided to follow the practice of the ICJ on challenge of adjudicators rather than the more exacting practice in commercial arbitration. We could also mention, in the same vein, the criteria to assess jurisdiction ratione materiale, which progressively align from one court to another, the similarities in the principles applied in case of non-appearance of a party, the similar application of the monetary gold principle on the indispensable party, or the case law on the costs of proceedings. With regard to transparency, as I said earlier, it is now current practice for Annex 7 arbitration to insert a specific section on transparency in the rules of procedure. It means that eventually the difference between unclosed court and tribunal with regard to transparency is not so material today, since Annex 7 arbitration no longer characterizes as being confidential in nature. Even when some procedural differences remain, and I want to insist here on the fact that they do remain some differences, these differences do not seem so significant that they would constitute a decisive incentive for the parties to do forum shopping in practice. There are, for instance, differences regarding the time frame within which Annex 7 tribunals should deliver their award, but when such a time frame is specified, it is in a recommendatory or best effort nature only. On a different plane, a number of Annex 7 rules of procedure contain specific timelines for the submission of objection to jurisdiction or admissibility, or some rules of procedure provide for a specific regime to prevent possible conflict of interest concerning the members of the tribunal and the agents of counsels of the parties. But on the substance, these regimes do not significantly depart from what is applicable before the ICJ or the ICLS. Conversely, the fact that something is not addressed in the rules of procedure of Annex 7 tribunal, while it is before the ICLS or the ICJ, does not mean that it is impossible to put it in place in the course of the arbitration. According indeed to Article 5 of Annex 7, arbitral tribunals can at any stage, I quote, determine their own procedure. For instance, even if in a case there is no specific provision in the applicable rules of procedure on challenge of arbitrators, the tribunal can adopt a procedural order to regulate the matter if a challenge is made, as it was done recently in the case. The same could be made in the event of a request for intervention. Even if intervention is not expressly provided for in Annex 7, which seems to constitute a major difference with the ICJ and the ICLS, nothing prevents an Annex 7 arbitral tribunal from putting in place a specific procedure to address such a request for intervention if such a request were to be made in a case. With regard to the capacity of the parties to decide on the composition of the tribunal, there is of course a difference between arbitration and permanent courts. However, here again, it may be that the difference is overestimated. A recent study of the sociological profiles of the permanent judges and the arbitrators show that they are not in fact so different. Moreover, we tend to forget that states have also their word to say on the composition of the ICJ and the ICLS because of the more and more competitive elections to become a judge in these courts. And in any event, the general consistency in the case law across all courts and tribunals seems to show that the composition of the court or tribunal is not really significant on the substance, at least in the great majority of the situations. Lastly, the cost of the procedure are also a potential factor that could drive a forum shopping approach. The ICLS and the ICJ are free to the enclosed parties, while arbitrators are to be paid by the parties. But in any event, the parties have to pay the cost of the counsel. In addition, there is a strong movement today towards improving the accessibility to international court and tribunals, in particular by addressing the issue of cost and funding of arbitration, as it is the case, for instance, today in the discussion at UNCITRAL on investment arbitration. It remains to be seen whether a comparable discussion will develop in relation to Annex 7 arbitration, especially in a context where both the ICLS and the ICJ face some budgetary difficulties. To conclude, The developments over the last 30 years revealed a much more complex situation than the one resulting from the apparently simple choice of procedure under Article 287 of the UNCLOS. Opportunities to do forum shopping at the same time multiplied and reduced as a result of these developments, which means that today states willing to do forum shopping have to develop sophisticated strategies without any certainty with regard to their concrete outcome. The question is whether the time devoted to such strategies is worth the price in terms of human and material resources in a context where, as I said, the jurisprudence of court and tribunal and their rules of procedure are generally convergent and where the choice of the forum is therefore likely to have no major impact on the settlement of the dispute on the merits. What seems more important since, and I will conclude with this last observation, what seems more important is that the developments since the entry into force of the Convention eventually show that, by and large, the UNCLOS succeeded in providing, in terms of dispute settlement, both flexibility and legal security, stability, and predictability, something which was not necessarily obvious to achieve when the Convention was adopted in 1982. That concludes my presentation. I thank you very much for your invitation, and I really look forward to the discussion. Thank you.
Thank you, Professor FORTEAU, for your insightful and informative presentation. I think he aptly captured complex and nuanced dynamics of how a choice of means may not incentivize the forum shopping behavior of states, at least not as much as anticipated from looking at the letters of the convention. Thank you very much.